a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, David Whiting, Melbourne solicitor, joins us in the studio. 1300 222 774 is the number, or you can text on 0437 774 774, and David will answer all your legal queries. And if he can't, he'll write it down and take it off as homework. Hello.
Hello.
You had homework, didn't you,
I
last
had
week?
3 lots of homework.
Three
We had
lots of
homework and 2 other ones.
That was a bit much for Easter, wasn't it?
Let's work backwards. Yeah, it was. But, you know, this is 3 4-day weeks.
Is it?
Yes.
Well, it might be for you.
Yes, it is. Well, okay, all right. It is 3 4-day weeks because next weekend is a long weekend as well for Anzac Day.
Yes, of course.
Yeah.
But not everyone gets all those long weekends.
No.
No.
Oh, my heart goes out to you. It really does.
No, it doesn't.
No, not at all.
Okay.
Last week we had Cedric from Watsonia was interested in, he was looking for a person, and the question is electoral roll search. And the answer's changed a bit over the years because the technical answer is that the electoral roll is available at Australian Electoral Commission offices for the purpose of searching. But you're not allowed record what you get on an electronic device. So it's a totally manual. You can look at an electronic database but only process it manually.
So you can write down the address.
You can write down, yes, you can write it down. So the answer would be it's there. They're not really keen on you doing it, but it's there.
How do you access it? Where do you go?
You will go to look up the Australian Electoral Commission and go to any one of their offices, and they normally have one in most electorates.
And make sure that you've got a pen and paper with you.
Yes, absolutely.
How ridiculous. I mean, that's just silly, isn't it?
Well, no, because it's an attempt to deal with this is supposed to be a publicly accessible document in an environment where we're interested in everybody's privacy. But what I find it fascinating is that political parties get a copy of the electoral database.
but also, if you can
rules.
access an address, what's the difference between typing it into your phone so you've got ready access to it versus writing it on a bit of paper?
Why are you being logical? It just doesn't work for the law. No? There's the law and there's logic.
Indeed.
Now, the second one was Olivia. Olivia rang. She had been the victim of family violence and wanted to make an application for criminal injury compensation. There's the Victims of Crime Assistance Tribunal, but which she can apply to within 2 years of the violence. But it's only for expenses. It's not pain and suffering. It's not that. Not like it's an insurance claim, but only for material loss. So
that would be for personal injury?
Yeah, personal injury. I mean, I once had a client who got all their teeth smashed in. So there was quite a large bill for dental work that was required as a result of the injuries sustained. So that kind of compensation. It might be plastic surgery for scarring. It might be all sorts of things. But if you're also eligible for compensation somewhere else, you have to deal with that one first. So within 2 years, unless it happened when you're under 18, in which case there's no time limit, and you can apply online at vocat.vic.gov.au, Victims of Crime Assistance Tribunal.vic.gov.au, and you can also download the form and do it manually.
And 2 years?
Yes.
Oh, thank you.
And the third one was low-hanging power lines, garbage trucks, low-hanging power lines, and damage to buildings when the cable turns out to be stronger than the front of somebody's house.
Now, strange you should say that, because that is indeed your homework, but also we happen to have a caller. This is purely coincidental, unless you'd organised it, David.
I did not organise it. No.
Stephen in Glenroy. Hi, Stephen.
Yes, it's about that very issue.
Yes.
I want to know, because there's supposedly a requirement for the communication companies to have them at a minimum height. Is there a statutory body or department that I can contact which will enforce that very thing?
Right. Okay. Well, that's one part of that question.
I don't think there is, Stephen, and I'm sure there isn't one. There will be an organisation. There will be codes of conduct, called codes of practice, that will require them to be installed at a particular height. But I don't think there's any code of practice that requires them to be monitored and checked and fixed from time to time. So they'll need to be put in at a particular level, but it will be a different rule after that. And I don't believe that there will be any organisation that does the policing. And of course, the difficulty is how do you know how high the wire is off the road by checking? So how do you check?
Get a ladder and a tape measure?
Yeah, but we're interested in the dip in the middle. We're not
Stop the traffic?
Stop the traffic. And the other problem, of course, is, Ellie, I don't really want to run a ladder up a power pole to see how close the live wires are. I just don't want to go there.
And indeed, where do they actually measure it from?
Well, it needs to be at the droop point, is it not?
Does.
It's the lowest point.
So what did you find with your third bit of homework?
Well, what I found was that it's the responsibility of the people who put the wires up to manage their droop, if you like, what's their low point, and there's a code of practices to that. But then in law, you have to take your victim as you find them. So if you were in a truck that ran into a low-hanging wire, you're the person who's primarily responsible for what occurs. It doesn't mean, so if let's say it's your house and the fascia board comes off because the wire was stronger than your fascia board, you have a claim against the driver, who's the proximate cause, who then has a claim against the wire company for allowing it to be in the state it was in. But in almost every instance, it's going to be cheaper
for you to just pay for it yourself.
For you to make a claim on your insurance.
Which is not particularly joyful. Or
No.
A couple of people just responding on that AEC going to the Australian Electoral Office to access information. Tony says most electoral offices are now closed. Camberwell is the only Melbourne office still open. And someone else actually pointing out that could be a real issue for victims of domestic violence.
Yes.
So is it,
it's this trade, is it not? There is a process by which you can become a silent elector.
Right.
So you can be enrolled, but your name doesn't appear on the register.
And how do you go about that?
There's an application that you make.
To the Electoral Commission?
Yes.
Right.
Yep.
Okay. 1300 222 774. David, thank you for... You've been so good at homework, aren't you? Were you always good at homework even when you were a kid?
No.
So you've reformed yourself?
Partially, yes.
Neil in Bentley, good morning.
Good morning. Thanks for taking my call. David, am I right in thinking that when an owner's corporation in their adopted rules doesn't have something that's in the model rules, that the model rule applies? And when the model rules change, for example, as they have done in smoke penetration in December last year, when will that become, if our owners corporation doesn't have a rule about that, when does that automatically become part of the...
Oh, wow. Okay, let's break that up into a couple of little bits. The owners' rules apply unless the model rules apply unless you tell everybody that they don't apply. Now, upon registration of a plan of subdivision, the model rules which
is the government set standard rules.
Here are your standards. They're attached to the Owners Corporation Act. They apply. Most people have rules that generally modify, or they're additional rules. It is possible to have a whole new set of rules that apply instead of the model rules, but most people don't do that. When do the amended model rules apply to owners' corporations, Neil? I hate doing homework, but I don't know the answer to that question. So when the legislation changes, do the model rules change too? Or the rules that apply to your owners' corporation change too? I'll let you know.
All right, Neil, so stay tuned next week. Gail in Bendigo. Hi, Gail.
Hi, Ali. Good morning, David. Our daughter purchased a two-bedroom unit, which is due to settle on Thursday, and the property next door is scheduled for demolition and then units built. When she signed the contract, the fence adjoining the neighbouring property was vertical, not great, but secure for her dogs.
Yes.
Now, at pre-settlement inspection yesterday, it's almost horizontal with missing palings and certainly not secure. Who's the best? She settles on Thursday. What would be your advice, David, as to her course of action?
The standard form contract that most people use under the contract, as a general proposition, the vendor has to deliver the property in the same condition as it was when inspected, and that would include the boundary fences. Now,
Right. So is it the agent and then the person selling?
Well, you're raising this issue with your lawyer or conveyancer, and you're saying, sorry, not in the same condition. The fence is a mess. The standard contract, and some people cross out this clause, say there can be a holdback of funds of up to $5,000 while issues relating to the quality of the premises at settlement can be worked out. So I would be going back to your vendor and saying, property not in the same condition because the fence was good. It was better than it is now. I want it back in the condition it was, and you can either do it prior to settlement or we'll hold some money back.
So the vendor through the agent rather than direct to the conveyancer, or both?
Well, sorry, have you got someone representing your daughter in relation to this transaction?
She is working with a conveyancer.
Yeah, that's fine. Well, then the conveyancer goes back and says there's this special condition in the contract. If you look at the property, the fence has deteriorated far more than wear and tear. Somebody's endeavouring to demolish it, and I want it back to where it was.
And make sure your bank knows if they're doing an automated settlement. So
well, no, it's the bank will only pay what the conveyancer tells them to pay. Yes.
Yep. Tony in Devonport. Hi, Tony.
Morning.
Hello.
How you going, Dave? Yes, first-time caller, long-time listener.
Oh, good. Nice to have you.
Yes.
How can we help you?
Approximately 2020, that's about February, I booked accommodation and flights to come to Melbourne. And come end of March, of course, the whole place turned upside down with isolation and pandemic.
Yes.
So I was given credits for the flights, which I ended up using September last year.
Yes.
But then I looked at my accommodation template from the provider of accommodation just recently. So I wanted to go because everything's reopened and travel restrictions are eased.
And you'd love to come to Melbourne. We quite understand that, Tony.
Yes.
So can you use your credit?
Well, I'm reading on the email I received from them. It said that I'm supposed to have told them any changes to my plans by the 16th of December 2020. Well, I didn't actually read that till recently because around that time...
Tony, did you book direct with the accommodation provider?
I certainly did, yes.
Right. Yep. And what was it? Look, I don't quite know the answer to your question. It's, as a general proposition... It sounds to me is that you had the opportunity of seeking a refund at the time, but you've chosen to apply it, or you struck a deal, or they simply offered you a credit and you accepted the credit.
They gave me a credit.
Yep.
And I said, well, I'll use that credit when I'm able to come over and use it.
Yes.
And there was a line in the email from the template saying, oh, you've got to tell us by the 16th of December 2020.
But does it actually say the credit will expire then?
No, it doesn't.
Look, Tony, I would endeavour to make the appointment and make the booking.
Yep.
And in the event that you don't get what you want, you might consider whether or not that's a reasonable term. You might want to argue about how much are we talking about?
$450.
Okay, it might well be worth the argument. You might go along and say, I thought it was an open-ended credit.
I'd go and have the conversation anyway.
I'd have the conversation.
Yeah.
I'd endeavour to make the booking,
Yeah.
Tony.
I'd contact them. I think that should be your first port of
Yes.
call. Kayla in Berwick. Hi, Kayla.
Hi there. A family member of mine is the unrecognised biological child of someone who is now deceased, and a former partner at the time of their death is making a claim against the will as its intestate.
Yes.
And they've made my family aware of this situation. And I wondered whether I'm thinking along the right lines to say that they shouldn't be represented by the same solicitor.
Sorry, so let's slow this. There is a person who has died. There is a solicitor representing the estate, right?
Yes.
Yeah, okay.
Oh, yes.
Quite likely.
And there's been a grant of probate.
Letters of administration for an intestate estate. If there's no will, it's letters of administration. Now, someone, a relative of the person who has died, is making a claim for a share of the estate.
Yeah, so there's...
And now you're wondering...
on the letters of administration, it was there was an affidavit submitted to say that the person had no partner at the time of their death and they had no children. And those people that signed that document have actually interacted with the child across many years and labelled themselves as grandparents.
Kayla, you have and what's your question then? Should your niece be challenged the estate?
Oh, 100%. I think she should.
Hang on. If there was no partner and your niece is the only child, then the niece is entitled to the whole of the estate.
Yeah, that's my question, because the person who is fighting to be recognised as the partner has then brought in my niece into the situation, because for a long time they didn't even know he had passed away because he had nothing to do with her. But
Kayla, not in a million.
Can I just get my question out? So then this person who's fighting to be recognised as a partner is offering up their solicitor to fight for my niece.
So your question is, should your niece take the same solicitor as the person who's fighting to be recognised as the previous partner, or be separately represented?
At the end of the day, it doesn't, like, if my niece will be recognised if she's recognised as a partner. However, my niece might not get her full share if this person's story isn't also investigated.
Yep. So should there be separate representation?
Well, they have completely conflicting interests in the event that the person claiming to be a partner seeks a claim. They're entitled to about the first $500,000 of the estate, and the balance would be split between the child and the partner. If the claimant partner is not believed, and the daughter, the undeclared child, succeeds 100% or succeeds at all, then the answer is the child is entitled to the whole of the estate. So it might be that they could work out a deal between them. How old is your niece, Kayla? In 20s, 30s, teens?
No, she's a child. She's under the age of 18.
Then there is just no way known that the partner should be representing the interests of the child. The child needs some separate representation and comes along and says, I'm the only child.
Kayla, thank you. That sounds like something that's going to be complicated. Tack in Toorak. Hi, Tack.
Good morning.
Yes, good morning. What did you want to say?
Yeah, I got a question about the window in the body corporate land, and the window was repainted. Well, now we want the window to repair, but the body corporate said no, it is our responsibility. And unfortunately, we can't find the strata title plan, but the window has been replaced. The whole block of the window has been replaced by the body corporate 10 years ago. They raised a levy for that. And
Zach,
then
when did you buy?
We bought it in 1998 or something.
Right. And when you bought, you will have got a copy of the plan of subdivision.
Yeah, but we couldn't find it, unfortunately.
Well, have a look. You can do a title search and get a copy of the plan of subdivision. Why I say that is that the rules have changed over the last 20 years. It used to be that the boundary between the common property and an owner's unit was the midpoint of the wall, in which case you would be liable for a portion of the window replacement and the owner's corporation would be responsible for the other portion. What's happened in the last 20 years is that for most plans of subdivision, the boundary is the inner face of the external wall, which means that the whole of the wall is the owner's corporation and therefore the whole of the window is the owner's corporation.
But is the owner's corporation's... I'm not sure what your actual question is.
Well, we want the owner corporation to pay for the repair of the window. And on the ground that the whole window was replaced, all the window on the block 10 years ago.
No, that's not going to get you where you want to go, Tack. Your argument is that the window belongs to the owner's corporation. But if you like, there's a difference between them paying to get it fixed and them arranging to get it fixed. I'm saying you ought to be reporting to them that there's damage to their property that needs to be repaired.
Tak, good luck with that. Jolie in Frankston. Good morning, Jolie.
Hi, Ali. Hi, David. Thank you so much for any help you can offer. I've got a 91-year-old friend who has a mass on her pancreas, and it's all looking pretty grim. And she's refusing to go to hospital, and it's all sort of happened over Easter, so lots of public holidays in there. And her son and I as well, her son is trying to nurse her at the moment, and she's refusing medical help. My question is, when it comes to end of life, if she does die at home without having seen a doctor, does it necessarily always have to go to the coroner? And I'm guessing that it does.
It will go to the coroner, but you are able to say to the coroner, I don't want you to perform an autopsy for the following reasons.
Okay.
Right, now, presumably, if you know she's got terminal cancer, somebody must have seen her a doctor at some point to get the diagnosis.
Well, she's had a CT so far, and all they've identified is a mass, but they haven't actually identified what that mass is.
All right. Okay, so we know he's got a tumour of some kind, but we don't know if it's malignant or not.
Correct, yes.
If he goes, or he or she goes to the coroner, you can simply ask that there be no autopsy, and this is why.
Jolie, we wish you all the best with that one. Patrick in Elstonwick. Hi, Patrick.
Hi guys. Our daughter's 17-year-old signed up for a gym membership with a local gym for a 28-day trial. She used her mum's credit card to do it, and we've just discovered she only went there for 1 month, maybe not even a month, but we've just discovered the gym's been charging us about $3,000 on my wife's credit card.
Yes.
I had a brief look at the terms, and my wife's been emailing back to the gym, and we haven't had a full response yet, but the terms are pretty standard. But the things that stand out is, one, my daughter didn't sign the contract, and there was a box at the bottom that you had to tick to say, I agree to all these terms. That wasn't ticked. As I said, she's 17 years old, and the terms say that a child may be admitted to membership, but that child needs to have the signed authority of their parents or guardian to be admitted.
Patrick,
and they don't.
Patrick, where are we trying to get to? I mean, I would be going back.
Want to get our money back.
Well, to get your money back, or to make sure that they don't keep taking it. So they've taken the money in advance, have they?
Yeah. Well, it's just been sitting there as an automatic bloody debit.
Oh, okay. So they've been taking money over time. I would be going back to them and asking for the money back. If not, I suppose the question's going to be: this is theft by your daughter, Patrick. This is obtaining it. What constitutes theft? The answer would be, the answer is, if I was to take Ali's credit card and go down and buy something without her knowledge or consent, that meets my definition of theft.
What if she didn't sign the document?
No. Her mum let her use the credit card. She didn't steal the money from her mum, but we all understood it was a 28-day trial. That's what they were promoting.
Not then an automatic debiting situation, which is what she's rolled into.
Right.
Yeah.
Yes.
Yeah.
Yes.
So
yes.
I'd be going back and saying, well, look, where's the paperwork? Because she didn't actually sign that you can continue to,
She didn't sign your agreement, give me my money back.
Patrick, good luck with that. It is so easy to get caught by those sorts of things. Just circling back to where we started, Pete the Garbo says the droop point varies greatly with a very hot day. Wires droop much lower at 38 degrees as opposed to a winter's day.
I can believe that.
Yeah,
yes.
So if you're going out there to measure, you'd want to pick your weather, wouldn't you?
You'd want to go on the hottest day possible, wouldn't you, to get some action?
Yeah, there you go. And we've also just had a call from Rod, who is a GP. He says his understanding is that as long as the doctor's happy to sign the death certificate, it doesn't have to go to the coroner. There you go. David, thank you. Nice to see you. Virginia will be back with you next Tuesday. David Whiting there, of course, Melbourne solicitor.